Senator Hagerty.
Thank you, Mr. Chair. Chairman Gensler, I'd first like to just start out by commenting on the fact that yesterday the SEC refrained from inserting itself into an ongoing court case regarding the determination of syndicated loans as securities. And as you know, this is a well-functioning market. It's got sophisticated market participants, and I was glad to see the Commission resist adding any uncertainty into such an important part of our credit markets. I'd like to turn now to the SEC and its agenda. As I mentioned in my opening statement, many of the rules promulgated under your tenure have crept well beyond the SEC's statutory mandate. And we're not talking about just a few rules. It's an eye-watering number. You just talked with Senator Manchin about the number of rules that you've undertaken so far, and you've pointed back to the fact that this is in line with what your predecessors have done. But I look back at the last 27 months of your two predecessors and the pace that you've undertaken here. And during the 27 months that you've been chairman of the SEC, and you've issued 58 rule proposals. That's nearly equal to the proposals by both chairs Clayton and White combined during their first 27 months. The sheer volume of this isn't the only problem, though. And again, you touched on this with Senator Manchin. The speed with which these new rules are developed and imposed on the market is just as important. And here, again, it feels that you're moving at an extremely rapid pace. This raises an obvious question, then. How does the volume and speed of rulemaking impact the quality of these rules? Well, here are just a few issues that were raised by SEC managerial employees that came directly from the Inspector General report that was conducted last October, that was printed last October. And I'll run through a few of them. And these are direct quotes. Shortened timelines during the drafting process. Limited time available for staff research and analysis. Limited feedback during the rulemaking process. Shortened public comment periods. Increased litigation risk, difficulties managing resources and other mission-related work. These are direct quotes from that OIG report. So my first question is, do you agree with the statements of the SEC managerial staff that were in this report that state, quote, the more aggressive agenda, particularly as it relates to high-profile rules that significantly impact external stakeholders, potentially, one, limits the time available for staff research and analysis, and two, increases litigation risk?
Again, I'm very proud to be part of such a dedicated staff, and I think they're doing excellent work. It's what we benefit from when we put these proposals out to public comment and we hear back, whether they see something that we didn't get accurate in the economic analysis, the legal analysis, the policies. In terms of the staff, I'm also pleased to say that we have, for a number of years, been very, this surveys done by the Partnership for Public Service, that we tend to be very highly ranked by our own staff about the work at the staff. But in terms
I'm talking
of the rules,
specifically about the OIG report, and here what they're citing is not process substance that you're talking about. It's talking about concerns with the process itself. Again, the speed and the volume that you're moving forward on. And here, it seems to me that it's a recipe for disaster, moving at this pace and this volume, particularly when you hear these types of complaints coming back from the staff. And the real victims here are the Americans whose livelihoods depend on returns from the marketplace.
you know, I appreciate that, but it's also, we put out to public comment, we have a rule docket that's these 50 to 55 or so, and we've been candid with the public through the administrative process about that's our docket, these 50 to 55 proposals. And we get the comments back and we adjust. I mean, the final proposals, the final adoptions reflect a lot of the comments that we receive.
If I could come back again where I started here, in terms of the tendency to exceed the mandate of the SEC. The regulatory agenda that you laid out, the increased budget request that you laid out, raises complicated but particularly germane questions, like how much funding would the SEC need if it weren't trying to do the job of the Congress, the EPA, the banking agencies, if it weren't bringing enforcement actions that are likely to be lost? Rather than struggle through the answer here, we'll get through that, to the questions for the record, but that's a very obvious question to me. If you look at beyond the mandate activities, we're funding those. What I do want to ask you is this: do you keep a tally of the cost of lost cases when you bring an enforcement action and lose, have you kept a track of the expenditures, the cost of that, both to the SEC and to those who have to defend against them?
We either settle or bring between 700 and 800 actions a year. And that's being a cop on the beat. And we lose very few, Senator, but we are going to it from time to time. That's the nature of our processes. So too would any law enforcement. We're a civil law enforcement agency. But it's really to protect the investing public and protect those firms that are trying to access the capital markets. And so we bring cases, whether it's Ponzi schemes or pump and dump schemes or accounting fraud, insider trading.
I'm talking about the statement cases, the cases that are meant for messaging. That is my great concern, and I don't think it's right to put American taxpayers on the hook for defending themselves in these cases when you know that there's a high odds of losing. That's the point here. I'll come back with questions for the record. We're out of time on this round, but I'll come back with questions for the record to try to get at this cost.
If I might just say, we only bring a case if we think that it's the facts and the law dictated, and it's really within the facts. We take it, our 5-member commission votes on every one of these. We end up voting between 15 and 30 of these a week, and we take this very seriously. We don't bring cases if we don't think there's been real wrongdoing.
Senator Durbin.